Hello, this is me again, Hadi Strømmen Lille. I have written this book, The International Law on the Aims of Education, and this is my second video to talk a little bit about the content of this book. I have also this video will be about chapter 2. I have also an intention to talk about something else than this book. I have other books, like I want to talk about books that I haven't written myself, like The Pure Theory of Law, Hans Kelsen. I'm reading through that, so I want to comment on that. I want to comment on Herbert Hart, The Concept of Law. So we'll see about that after a while. But for now, this is just going to be about chapter 2 in this book, and it is, the headline of this book is International Law on the Aims of Education. And so one of the central questions is, what is international law? And is it real international law? Is it real law? Or, yeah, well, it's a big question. Now, the first, to address this question, when we talk about children's rights, and I used to work for Save the Children for many years, and I've been in this field, this business of the Convention on the Rights of the Child and Children's Rights for many years, and this book is also very much about children's rights, because it's about the aims of primary and secondary education. Sometimes, quite often, I would say that people talk about rights when it comes to children's rights as if it's something that is universal or comes from, they say things like all children have the same rights everywhere in all situations, or they say that all children have these inherent, inalienable rights. But where does it come from? Where does it come from? So I start off this chapter by trying to discuss the difference between natural law and legal positivism. Natural law is a branch, I would say, of philosophy, or a way of looking at rights, and human rights especially, or law, in which you think that you would argue that you find law. Law is something that is not made by human beings, but is innate in our reasoning, or it comes from nature, or it comes from God, or we don't. It's a matter of rights being something that is above the legal system in itself. You would ask questions like, is the legal system just? If it's unjust, it's not real law. Now, whenever you want to, if you want to find the methodology, if you want to ask yourself, well, how do we interpret children's rights, or any rights, or in this case the aims of education, where do we turn to? And it's the same for any field, not just law. You have to, students have to learn to substantiate their arguments, and the best students, they can discuss the strengths and weaknesses of the evidence that they present to argue their case. And within law, we call that legal sources. So where are the legal sources? If you say that we have inalienable, universal rights. So some people, they start to refer to the Convention on the Rights of the Child. So, the children have universal rights because it's based on this treaty. What is a treaty? What is the Convention on the Rights of the Child? Does it come from God? Does it come from nature? No, it's absolutely not. It's a treaty. A treaty is a legal contract between states. And although it's been ratified by almost all countries in the world, it's still a treaty. And the product of and it's a political compromise. It's not based on, it's not divine, it doesn't come from God. Those who were those who were participated in the negotiations about the wording of the Convention on the Rights of the Child, they are not divine people. They don't represent divine states. So it's like it's sort of absurd. You can argue that there are such a thing as universal rights, and I don't deny that. It might, and you can refer to, but when you do that, you have to be careful. And how do you where do you turn to substantiate your arguments? So there are certain ways you can turn to moral philosophy. Some people turn to Kant, although I would dispute that. I would think that, well, I have quoted Kant in which he says that he doesn't believe that there is ever existed the kind of pure rationality that he is talking about. He talks about rationality, a free will, if you may, a free goodwill that is sort of liberated from self-interests and inclinations, as he call it. But then he has this little reflection, and he says, well, I'm not sure that what I'm talking about has ever existed, because I don't believe human beings are this liberated. They are not that rational that they think they are. So even Kant doesn't really, but he says, oh, well, okay, well, even if it hasn't existed, I think it's important, he said. Okay, fine. Let's say that you believe in universal rights. Maybe you can refer to Kant. Maybe you can refer to, John Locke, for instance. He had arguments about that. But don't refer to a treaty made of human beings, like the Convention on the Rights of the Child. Don't refer to even the Universal Declaration of Human Rights. It doesn't come from God. It doesn't come from nature. It's a product of human beings. So how do we interpret treaties? That's if we're going to talk about real international law, we have to sort of, it has two pillars. International law is based on treaty law and international customary law. And there is this one treaty called the Vienna Convention on the Law of Treaties. And it has three articles, Article 31 to 33, which is about how to interpret treaties in general. These provisions have become part of what we call international customary law. It means that almost all states, international courts, international treaty bodies, courts of law in states and between states, they refer to these provisions to interpret treaties. Although they haven't, states refer to them, although they haven't ratified this treaty, the Vienna Convention on the Law of Treaties. But where they don't know where else to turn to. So it's become, that's an example of how some norms have become universal, sort of customary. So if that is what you mean when you talk about universal rights, fine. Then argue why it has become part of customary law. But you can't say that all the provisions of a treaty necessarily is part of customary law. But anyway, fine. How do we interpret Article 29 of the Convention on the Rights of the Child or any other treaty provisions on the aims of education? Article 31 in the Vienna Convention on Law of Treaties, it has paints three basic principles of interpretation. and I will find it because I think that it's important to read it. It says, a treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose. So we have good faith, you have the ordinary meaning, you have the context, and you have the object and purpose. So there are like four basic rules of interpretations. So I go into that and I try to explain, but much of what I'm saying about these four issues has been written about before. But my main point now is just that if you don't know anything about treaty law, you can refer to what I'm saying here, because it's specifically tailored toward the Convention on the Rights of the Child. But I won't go into detail about how to apply these principles now. What I want to address is that the second question, I had two questions. What is international law? The second, and where do we turn to? I mean, the Vienna Convention on Law Treaties, these four principles. And then the second question I had to ask was, well, sometimes we have these international human rights provisions, but they are not really provisions of law. Let me give you an example. For instance, there is I think it's Article 24 in the Convention on the Rights of the Child that says that all children have an inherent right to the highest standard of physical and mental health. Well, what if they get sick? If a child gets sick, does that mean that the country has violated the Convention on the Rights of the Child? No. And how are you going to how should one apply such a vague, elusive provision in a court of law? It doesn't really say anything about the obligations of a state. It's more like a political loose aim. So I wanted to know, is that the case for the aims of education? Is it more a political, non-applicable provisions of treaties? So there are two ways of two central questions to answer that question, that problem. First, I have to establish or find out, is it applicable in court? Can the court use these kinds of provisions to substantiate obligations and rights? And indeed, there are many cases that courts have addressed and have used the aims of education to say something about legal obligations, and the most, I think, of all the international cases, I think there is a Canadian case, Ross versus Canada, which is the most, which I dedicated quite some pages to discuss. It was about this teacher in Canada who had been writing in debating in public debates, arguing his views about Jewish people, and these views that he was publicly stating was quite racist against Jewish people. And so there was a human rights commission in Canada, and there was this Jewish dad, and he complained again, says that this teacher, he is creating a poisonous environment towards Jewish people, including my children. And so he took the case to the Human Rights Commission, and they decided that the school board was indirectly responsible for this poisonous environment, because they hadn't fired this teacher. So they decided that what ended up is that this teacher was relocated to a non-teaching position. So he argued that this was a violation of his freedom of speech and his freedom of religion. So he took the case to the Supreme Court all the way to the Supreme Court of Canada, and then when he lost there, he took the case to the United Nations Human Rights Committee, which is the treaty body for the Covenant on Civil and Political Rights. And he argued that his right to freedom of expression and freedom of religion was violated. Now the committee, they looked mostly at the issue of freedom of expression. And they would, because the right to freedom of expression and also the right to freedom of religion is not an absolute right. So under certain conditions, states and authorities may, if it's necessary to, for instance, protect the rights of others, they may limit these freedoms for its citizens. So they looked at this reasoning and they said, okay, teachers have an obligation to respect and promote the aims of education, which includes the aim of promoting respect and tolerance towards Jewish people. And so they say, okay, this teacher cannot function as a teacher if he undermines these basic aims of education, these basic values of education. And so the Canada, they would argue that, well, he is free to say these things as an individual. And also the Human Rights Committee agreed with this. They said, okay, he can be quite racist towards Jewish people, but not as a teacher. So if he wants to work as a teacher, he cannot be saying these things, because then he has a duty to protect and respect the aims of education, which includes promoting respect and tolerance for Jewish people. So this is just one example of how the aims of education, and there are also, quote several other cases, similar cases. Even in Norway we also have these cases in which teachers have been relocated or fired because of what they have said in public debates, and it becomes a debate about freedom of expression. So okay, fine. It is applicable in court. There are numerous examples of that. So it's not like the aims of education are not completely unapplicable. Without subsidy they can't have any function. So it has a function. Teachers are obliged to respect and protect them, even in their free time. Okay, fine. The next question I had to address to see if this is real law or not is that, well, if some would argue that if a law is so ineffective, if it's not respected by any individuals, or in this case states, then it's not the real law. And one can argue that these provisions on the aims of education, they are not really respected by many states. There are not many states that have adopted these detailed plans of how to, even though the Committee on the Rights of the Child and other treaty bodies, they are banging on about these aims of education, but nobody really cares. So you can say that, oh, because they don't care, it's not real law. Now, to address this is one of the most classic questions of legal debate or jurisprudence. And so I turned to basically one of the classics, which is Herbert Hart. Herbert Hart wrote this book, The Concept of Law, in which he discussed basically what is law and what is not law, and he comes to this question about effectiveness. And I'm just going to say what I found is one quote from him, and he says that if by efficiency is meant that the fact that a rule of law which requires certain behavior is obeyed more often than not, it is plain that there is no necessary connection between the validity of any particular rule and its efficiency. We must distinguish a general disregard of the rules of the system. So sometimes I mean, sometimes states just violate laws. Their disrespect means a violation of the law. It doesn't mean that the law in itself is not valid as a law. And so, okay, fine. That's one way of looking at it. And then I find, is there any other parameters? How do we distinguish different provisions of international human rights law and say, okay, this is a law and this is not a law? This is valid, this is not valid. And so I try to address this by looking at the Organization for Economic Cooperation and Development. They have this it's called the PISA program. And it's a program for assessing if children have learned certain subjects in school and how well they have. There is a series of exams that all countries in this organization, is like 80 countries. I don't know how many countries which are part of the PISA, 80 states. And so it's all, even Canada, Norway, and so these are aims of education. And what is striking about the PISA program is that states go out of their good skin to compete with each other about achieving good exam results on these aims. These international organizations which have defined some aims of education, so these are important, we will assess all countries have the same. But are the PISA program aims law? It's not a treaty. States have not committed themselves in any process of saying we commit ourselves to uphold these educational aims as a legal commitment. Absolutely not. It's just some loose international cooperation of some sort. But it has no legal value. And so I would argue that there has to be, if you look at the Convention on the Rights of the Child, if you look at the Covenant on Economic, Social and Cultural Rights, Article 13, these are real treaties. And although states doesn't seem to compete with each other to be as good as they can to achieve these aims of education, these provisions of treaties have a more legal character and then the PISA program aims. Okay, well, anyway, that's how I try to address that issue. If I'm successful or not, I don't know, I try. But it's sort of, to go to the rest of the book, I have to sort of establish, is this real law or not? Can we, is it, because if it's not, why bother at all about writing a book about the aims of education and how they should be interpreted? Okay.